In this video, I'm going to talk to you about probation violations in the state of Arizona and how to defend petition to revoke your probation. Hi, I'm Alatorre, owner-director of Alatorre Law. I'm a criminal defense attorney in Tucson, Arizona, and I help people fight for their freedom and protect their future. Let's get on with the video. What is probation? Well, probation is a type of sentence that a judge can give a criminal defendant, and the effect of probation is the actual incarceration sentence is suspended, and then the person just gets placed on probation, which is basically a type of release subject to the person complying with certain requirements or condition. These conditions are called conditions of probation. So basically, when your person is found guilty of a crime and they qualify for probation, some crimes qualify for probation, some don't. So if a person qualifies for probation and you are found guilty of that, then you get, the judge at sentencing has to decide, well, is probation appropriate or not? If you got a decent lawyer and the facts are helpful, basically, the judge will suspend your sentence. Whatever range of sentence of incarceration will be suspended, and instead you will be set for a specific term of probation, depending on the charges and the level of offense, what kind of term of probation you're looking for. That's basically what happens. So you are sentenced, you are giving, let's say, 3 years probation, and you're giving a written list of conditions of probation. These are the terms or conditions of probation that you have to comply with. What are they? Well, law-abiding behavior, right? Don't commit a crime, right? Crime-free lifestyle. Don't possess a firearm. Another one that's kind of quirky is you have to submit to searches of your home and your stuff by your probation officer without a warrant. You have to report to probation every so often, depending on what type of probation you have. You have to maybe go to counseling, maybe some drug treatment or something like that, domestic violence counseling, stuff like that. It just depends on the case, right? For example, another requirement would be community restitution, no contact with the victim, and even a term of jail as a condition of probation has also been a possibility. So it said, well, I'm going to put you on probation. So instead of sending you to prison for 10 years, I'm going to put you on probation. You're going to do 6 months in county jail, and then you'll be released on probation for 5 years, 3 years, whatever it is, right? The judge has a lot of leeway and discretion on that, and that's all happens at sentencing. There's different types of probation. You have domestic violence probation, which has specific requirements when you're convicted of a domestic violence offense. And then you have IPS, in prison soon, intensive probation. In intensive probation, one of the most draconian or more serious charges or conditions is they actually make you have like a weekly or daily schedule, if you will. So at this time, I'm going to go to work. At this time, I'm going to go to the gym. At this time, I'm going to go here. And you have to keep it. You have to do exactly. And then you have an ankle monitor or whatever. If you don't do it, that's a problem. So probation is basically prison without the walls, or jail without the walls, depending on what kind of charges or whatever you got convicted of, right? But basically, you are not completely free. You have things you have to do, and you're subject to a bunch of things that normal people are not. So before you take probation, make sure you understand those terms, because some people are like livid when they actually figure out what it is. They don't know what to do. They can't take it. All right, so that's what's probation. But what is a probation violation? Well, remember all these conditions that they give you that I was telling you about? All these conditions that you have to comply, like don't drink or whatever, don't do drugs. Well, if you don't comply with them, your probation officer can file a petition to revoke your probation, which basically means taking you back to the judge so that instead of probation, another sentence can be given. So potentially that incarceration sentence that was suspended, you could potentially get sentenced to that. So how does this work? Well, there has to be some kind of violation, some kind of situation going on. But let's assume your PO decides, oh, you violated. So your PO can handle it different ways. One way, they could get a warrant or whatever, order the judge, file the petition with the judge, order a warrant to get you picked up and brought to court, they bring you to jail. But your PO can actually arrest you, him or herself, without a warrant. Okay, so let's say your PO goes to visit you or whatever and finds a bunch of drugs or whatever. You can put cuffs on you and take you to jail right then and there, and then you'll see a judge within a few days. So what happens? You get arrested. Well, you had an initial appearance. You get arrested on a probation violation. So the first thing's going to happen is you got to be taken to see a judge without unreasonable delay. The court will advise you of your right to counsel. They'll inform you that any statement will be used against you. They'll set a date for your revocation arraignment, and they'll make a release determination. 99.99% of the time, there will be no release. You will be held without bond until the judge decides. And that's it. And after that, They just send you back to jail, and within 7 days of that initial appearance, you'll have your arraignment, or your revocation arraignment. So an arraignment normally is when you actually initiate a case and you're charged with a crime and they ask you how to plead guilty or not guilty. This is something similar, but this is not guilt or not guilt. This is basically here, they're not saying you committed a crime. They're saying you violated these parts of your conditions of probation. So what happens is the petition actually will list what sections of your conditions. They're numbered usually. So say number 5, number 6, whatever, standard conditions, special conditions, whatever. They identify which ones on the document that you receive with your conditions. The petition identifies those, right? So at your revocation arraignment, that's where you'll see the judge, and the judge will inform you of each alleged violation, right? So instead of informing you of your charges, here they're informing you of, well, Mr. So-and-so, your PO says you violated these terms of your probation. And you can either admit or deny those, right? If you admit them, they send you a dispo, because it's kind of like sentencing, and we'll get to that. But one of the things that I have to point out is most people just pick one and admit. You shouldn't do that. Talk to your lawyer. You have a right to counsel during a probation revocation proceeding. Talk to your lawyer first. If you get a decent lawyer, your lawyer will try to speak to the prosecutor ahead of time, see if you can enter an agreement like a disposition agreement. Instead of a plea agreement, it's a disposition agreement. Some jurisdictions do them, some don't. Some prosecutors just say, well, plead to it and we'll see. I don't know. We'll see. It just depends. Unless they give you something, I would never. I mean, if you don't get any specifics and you just make an admission, you're kind of taking a lot of risks. So I would never recommend a client of mine to actually just admit without an agreement with the state. If they're not going to give you an agreement, screw it. Don't admit. Set it for a revocation hearing. Have them prove it. Have the prosecutor, have your PO prove whatever the fuck they say you did wrong. Now, if on the other hand, they're giving you some love, they're giving you some sugar, right? They're saying, oh, look, just take this one and we'll dismiss the other ones. We won't make a big deal about it. Well, then maybe that's what you got to do. But you got to talk to your lawyer, figure out what your exposure is, okay? So basically, if you don't admit within 20 days after your arraignment, you will have a hearing. Now, remember one thing. You're in jail during this whole time. You're all over the place. You're still in jail. At your arraignment, you can ask the judge for release. It's rare, but it happens. I've gotten it done before. It happens more when it's like a technical violation, or like, oh, you didn't call me at 5, so you call me the next day or whatever, the probation violation. When you're admitting that when they're alleging those kind of just technical violations, not like you committed a crime, right? No, you just like a technical violation is like, oh, you should have reported on Thursday and you didn't come until Friday. So if you're admitting to those, or if they're just alleging a bunch of those, like not major issues, a judge will be more inclined to consider release. But for the most part, you're going to be without bond and in jail. That's why these terms are so important. So anyway, once you don't admit at your arraignment any violation, the court will set a violation hearing within 20 days of that arraignment. The violations need to be proven by a preponderance of the evidence. So this is not a criminal trial anymore, right? This is just a violation hearing. So preponderance of the evidence is like in a civil case, more likely than not. That's all they got to prove, not beyond reasonable doubt. That's not what's going to apply there. So each party you do get to present evidence, and you do get discovery, okay? So a lot of people don't know this, or just don't bother. You can get discovery from the state. There is case already out there that says that the Rule 15 or the disclosure procedures or requirements of the Rules of Criminal Procedure are extended to sentencing proceedings and to probation violation proceedings. So yeah, you do get some disclosure. So you're entitled to discovery from the state. You get the discovery, get your probation records. You want your lawyer to review all those, right? You want your lawyer to review the records from their probation, make sure that the violations are there, see if you have some explanation for those in those records, because that's the best source, because they do keep some records of your performance. You also want to show the judge, when the judge gets to decide the violation and the disposition, you want to show the judge, even if you actually violated, how well you were doing on probation, because that's going to dictate what the judge is going to do after that. So it's basically a little trial to the court, to the judge, and the judge decides if you did violate any of these based on the evidence presented. They do get to present some hearsay evidence, stuff like that, but for the most part, you do get due process, and there's good. I've done some of these. It's good due process, especially if the prosecutor and your PO want to just send you to prison. Yeah, you want to fight it. So you go to your violation hearing. The judge says no violation. He puts you back on probation like nothing happened. You just get released. If he does find a violation, then he sets a disposition hearing. At that hearing, the court, it's kind of like sentencing, but it's not sentencing. Now it's disposition. How are we going to dispose of the case? So the court may revoke, modify, or continue you on probation, right? So it depends on the violations of the facts and all the circumstances the judge will decide. If he revokes, he then has to sentence you for the prior crime. He then has to go back to what the other judge did. Maybe it's the same judge, maybe it's not. What the other judge would have done at sentencing and consider what appropriate time of incarceration is appropriate based on the original case. He can't sentence you and punish you because you violated probation. They can't do that. Not in state court anyway. In state court, a probation violation does not get you prison. It just gets you revoked from probation and then sentenced on the original charges based on the original facts. The judge decides, he continues your release, he can extend your probation, he gives you a higher degree of probation. The judge can pretty much do whatever he wants based on those ranges and based on the information he has. And then finally, what are the defenses? Well, you can negotiate that disposition. It's kind of like a plea agreement. Or you fight the evidence. You attack the evidence. Okay? It's not usual, but sometimes you don't have a choice. And I've done those. It's pretty interesting. It's a bit of a different process. It's not exactly a trial, but it is an evidentiary hearing to a judge, right? And the judge decides. Okay? No jury. And that's basically it. That's the process of probation violation in the state of Arizona. I hope this video has been helpful for you. If you or somebody you care about has facing criminal charges in the state of Arizona, give us a call. My contact information is on the description down below. Give us a call. We'll set you up for a free case evaluation and see if we can help. I hope you found this video helpful, and I'll see you in the next video.